Subscribe to our YouTube channel and click the bell icon.
Mr. Datar, I wanted to ask you about the public interest litigation jurisprudence, and there is criticism of judicial activism against the judiciary with respect to PILs, and I wanted to sort of ask for your views. Do you think that criticism is justified?
Well, I think one of India's contribution to world jurisprudence is this concept of public interest litigation. At any seminar, at any global conference, people are quite astonished at the kind of orders our courts are able to pass. And in fact, the PIL really highlights the topic which has been rightly chosen by Lord Goldsmith: who governs, government, parliament, or the judges? Now, this is the classic separation of powers from the time of Montesquieu, that there is an executive, there is a legislature, the judiciary. And the question is, who is supposed to govern, who is actually governing, or who is not governing? And that's where, in a sense, the PIL comes in. I have two things to say. I think, as once again, it's a mixed blessing. I would not say that PIL is a force of evil or it should be completely jettisoned. No, it has got its place. I know, for example, you take in 1979, when there was a series of articles in Indian Express, 40,000 under trials were released, were unlawfully detained. I know in my own case in the Madras High Court, we had a very active green bench before the Green Tribunal came, and we were able to stop pollution in a number of cases. I know other high courts which have really supported human rights, environment, and PIL has been broadly based on either human rights or an environment in the initial stages. I think where it has gone out of hand and it has become really widespread in not all welcome ways is that we have not placed enough emphasis on the rule of locus standi. Who is the person coming to court? And if you read Justice Bhagwati's judgment in the first judge's case, he said that the PIL is meant, and I'll read what he said, the PIL is meant for, he said the PIL is a new method and a new strategy to provide access to justice to large masses of people who are denied basic human rights and to whom freedom and liberty is of no meaning. So basically, large masses of people who could not approach courts because of sheer poverty. And this was basically a writ petition, a class action writ petition, if I may say so, that you have a class action of a large number of, say, bonded laborers or under trials or people in remand homes and so on and so forth. This was the basic object of PIL. And I think it played a stellar role in controlling pollution. In fact, I would say that, for a large period of time, the entire forest of the country was managed by the Supreme Court. They were able to prevent large-scale deforestation through these laws. Illegal mining was checked by these PILs. But now what's happening is, it is going, I think, a bit too far. And I have my personal view is there should be clear directions. In other words, there should be clear rules. As Pratap rightly mentioned, that you may have different number of courts, but if there's a clear principle, I should know that if I go to the court with this particular petition, these are my chances of success. These are the minimum standards I must qualify. You have a PIL recently filed saying that drop secularism and socialism from the Constitution. We have a PIL in one of the High Court saying that nobody can access social media without an Aadhaar card. And it is entertained and it just goes into different directions. And what I think the first is the issue of locus. The other problem with the PIL is that courts are not equipped to pass orders which have got large-scale consequences. I mean, huge collateral consequences. Take, for example, this diesel cess. Now, as a student of law, I don't know what power a court has to say that impose diesel cess and apply it in this particular. It's a completely legislative function. It should not have been done at all. That's my personal opinion. Where is the power? Article 142 is there, but that doesn't allow you to legislate. Take the example of, say, for example, the BCCI matter. It started as a betting scandal, and then ultimately it went to a case where the Supreme Court virtually said that how the cricket administration should be there, what kind of constitution it should have, and so on. Which I thought is, in my personal opinion, not the role of the courts at all. And I can give any number of such examples where it has really gone out of hand. And I think it's now time to bring it back, lay down clear principles. As I said, I would prefer some practice directions or some clear norms that, first of all, who's the petitioner? Whose cause are you espousing? Is that person unable to come to court, number one? Secondly, if, as Lon Fuller said, that these are all polycentric disputes, when you simply ban diesel cars, you have huge implications. And I don't see why the Supreme Court of India should get into a question whether we should have BS3 standards of vehicle emission norms or BS6 standards entirely for Parliament to decide. So I think in some areas we should now make it very clear that court should not step in, particularly where there is extensive collateral damage that can be caused by court orders. And again, of course, PILs have been used to good effect, but I think it's a time for very, very deep introspection by all the courts and all the Supreme Court, and the Supreme Court especially. And we have clear norms throughout the country that these PILs are not to be entertained. And lastly, the other major problem in India is there is no system of costs. Whereas in UK, you file a case, you could be visited with heavy costs. Here, anybody can file a PIL, gives notice to the other side, the matter goes on for several weeks, then it is dismissed or it goes to Supreme Court. And who bears the costs? It will be a completely frivolous petition. So to answer your question, I think it's time for a reality check and a very, very close introspection on PILs with clear rules being laid down.